All right. All right, this is case number 22 CR 17, State of Ohio versus Julia Ann Midkiff. This is a hearing on evaluation for a report for mental status of Ms. Midkiff. She's appearing by video from the facility. Our attorney is Danielle Witt, appearing from her office, and also appearing from the prosecutor's office is Assistant Prosecutor King. The report received, well, for the record, the defendant has previously been found not competent to stand trial, being charged with burglary and theft, a second-degree felony and first-degree felony, and had been committed to the Twin Valley Behavioral Health Unit for competency restoration. The court received a report dated November the 13th, and that report indicated that she was still presently unable to assist in her defense, and that her ability, competency remains impaired, and therefore continued treatment is necessary. Now, have each of the attorneys received a summary or a copy of the report?
State has, Your Honor.
Yes, Your Honor.
Does either counsel wish to present any further evidence regarding the matter?
Nothing from the state, Your Honor.
No, Your Honor.
All right. Well, the court then will find that the defendant is still not capable of understanding the nature and objective of the proceedings and consulting with her counsel regarding the pending charges, and that her current placement is still the listed or least restrictive placement that's consistent with protection of the public, and therefore it's the order of the court that her commitment will continue until further order of the court, subject to the mandatory reporting updates from the treatment facility. And the court will put that on. So you'll remain there at the facility, Ms. Midkiff, until we receive another report and then regarding your case. All right. Thank you. All right. You can go ahead and start. All right. This is case number 23 CR 219, State of Ohio versus Russell Eugene Dunn. This is a bond review hearing being conducted pursuant to statute. Mr. Dunn was arraigned last Friday, I believe it was, on the charge of aggravated possession of methamphetamine, a fifth-degree felony. This is hearing being conducted by Zoom. He's appearing from the jail. Appearing on behalf of the defendant is his attorney, Danielle Witt, and appearing on behalf of the state is Assistant Prosecutor King. Ms. Witt, would you like to be heard regarding the matter bond?
Yes, Your Honor. We do ask the court to reduce the bond to an OR bond effective December 18th. It's my understanding that Ms. Sturgill has obtained a bed at the Rulon Center for him, and since this is a lower level F5 possession charge, we ask that he be permitted to start his substance abuse treatment.
Mr. King?
I would just just make the court aware, Your Honor. I don't believe the defendant has any prior felony convictions, none that I could see at least prior to a quick check. I did see where he failed to appear on 2 separate occasions in Hillsborough Municipal Court this year. So that's all the state has to offer, Your Honor.
Well, I do have a note of that in July, there was a warrant for failure to appear. There was a previous failure to comply. It looks like that was a first-degree misdemeanor back in 2019. And receiving stolen property was also a misdemeanor. So it appears that all the convictions are misdemeanors. So where's the placement available for Mr. Dunn?
The Rulon Center.
All right, and Mr. Dunn, is that what you want to do? You want to go to treatment?
Yes, sir.
All right, well, let me explain something to you. Right now, you're charged with a 5th-degree felony, and since you have no prior convictions for felonies, if you're convicted, it's mandatory that you get community control or probation. But if I release you on your OR bond, you go down to the center, it's going to be conditioned that you be there and stay there, and if you leave there and you violate your OR bond and you don't show up for court like you have in the past here in the last few months, you'll be subject to being prosecuted for a felony, which is a 4th-degree felony, and that means you can be sent to prison because you commit that offense while you're under bond for another offense. So, you know, if you look at this as an opportunity to get out of jail, walk in the front door, walk out the back door, and go back to whatever it is you want to do, you'll be punching your ticket to prison. You understand that?
Yes, sir.
All right.
I just want to change. I have a chance to change my life, sir.
All right. Well, I'm going to grant the reduce the bond to OR only, with the condition that you all the conditions I ordered the other day, which is going to include pretrial reporting and being supervised by the probation department. It's also going to be the additional condition that you enter into and remain in the Rulon Center program during the pendency of the case. And if you fail to do that, then you know, there'll be a warrant issued for your arrest. And if you don't show up for your court dates, most likely you'll get indicted for another offense, which, like I said, it's a 4th-degree felony. It's more serious than the one you're facing now, and would mean that you could go to prison. All right? You understand?
Yes, I understand completely.
All right. When is the bed available, Ms. Sturgill?
On the 18th, sir, that's when his time is up for municipal court, so we pushed it until then.
All right, so that'll be effective December 18th. All right. Thank you.
Thank you.
All right, this is case number 23 CR 222, State of Ohio versus Joseph D. Hauser. Are you Joseph D. Hauser, appearing there from the jail?
Yes.
All right. This is a bond review hearing being conducted by Zoom. Mr. Hauser is appearing from the jail. His attorney is Jacob Wagner, appearing from his office. Appearing from the prosecutor's office, Assistant Prosecutor King. The defendant was arraigned last week on charges of involuntary manslaughter, corrupting another with drugs, aggravated trafficking in drugs, trafficking in fentanyl-related compound, possession of fentanyl-related compound. And this is a review hearing being conducted pursuant to statute. So, Mr. Wagner, would you like to be heard on the matter of bond?
Yes, yes, Your Honor. Excuse me, sir. Apologize. Your Honor, while we appreciate and understand the serious nature of these charges, I have been in contact with my client even prior to this indictment through a children's services case. He's appeared in court. If it's the same Mr. Hauser that I'm aware of, again, we've met in court several times. He's always appeared. We would just ask for any reduction the court would be, that would deem appropriate, Your Honor.
Mr. King, on behalf of the state.
Thank you, Your Honor. Given the serious nature of these charges, the state would just ask that the current bond remain in place. Would also note that during the arraignment last week, the court noted, I believe, a previous failure to appear in Washington Courthouse Municipal Court. So based on that, the state would ask that the current bond remain. Thank you.
All right. Yeah, I do note that on 4/13 of 21, there was a warrant for failure to appear out of Washington Courthouse. And then it involved, looks like, 2 different accounts of domestic violence at that time. And based upon that, the nature of these charges, the mandatory sentencing involved, the court will leave the bond in place. All right, thank you. That's it for bond reviews?
Yes, Your Honor.
Okay. Number 22, CR 218, State of Ohio versus Sarah Ann Kennedy. Are you Sarah Ann Kennedy appearing there from the jail on the screen?
Judge, you're muted. We can't hear you.
Oh. I'm sorry. Are you Sarah Ann Kennedy appearing there from the jail?
Yes, sir.
All right. This is a sentencing hearing. Ms. Kennedy has previously entered a plea of guilty to aggravated possession of methamphetamine under 2925.11, a fifth-degree felony. Her attorney is Danielle Witz, appearing from her phone. Appearing on behalf of the state is Assistant Prosecutor King. Ms. Witt, are you and your client both in agreement this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
Yes, we are.
And you're all right with that, Ms. Kennedy?
Yes, sir.
All right. As I indicated, Ms. Kennedy has entered a plea of guilty to aggravated possession of methamphetamine, a fifth-degree felony. The matter was referred to the probation department for a pre-sentence report. I have received that report. Have each of the attorneys received a summary?
State has, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only what is contained in the plea agreement, Your Honor.
All right. Ms. Witt?
Yes, Your Honor. We asked the court to follow the joint recommendation. While it doesn't appear that Ms. Kennedy is eligible for drug court, we do ask that she be able to continue in her mental health treatment and to be on community control. This is a 5 lower level felony, and at least from what I've seen, she only has 1 prior felony about 10 years ago. So ask the court to take that into consideration.
Anything you'd like to say, Ms. Kennedy?
Yes, sir. I didn't speak before because I had asked my attorney to maybe try to get me, like mental health treatment or outpatient treatment because I was at CBCF in Columbus back in about 2016. They dismissed me because of my health. I went to ACM, Another Chance Ministries. That was in Chillicothe. They dismissed me because of my health. So please, sir, consider maybe outpatient or something of the sort. I would like to do successful completion of everything you ask.
Well, when Ms. Sturgill interviewed you for the drug court, you said that you don't have a drug problem. You can stop whenever you want. I just want my medication.
Yes, I'm at my bipolar medication.
Are you currently receiving, are you currently under a doctor's care for bipolar?
Yes, sir. I was being seen by Integrated Services, by Sky Work, and she was prescribing my Abilify and my Zoloft since I've been here.
Is that in Chillicothe?
Yes, sir.
All right, so that's where you're getting your prescriptions.
Yes.
But you're not in any other kind of mental health treatment at this time?
No, sir.
All right. All right, well, Ms. Kennedy, you're, as far as the court giving you help, that's not, that's not what we do. You have to get help for yourself.
Yes.
We can refer you to places,
Yes.
and I'm going to make a condition that you comply with your treatment program, but it's, you're the one who has to go back to your mental health providers and make sure that you're seeing them and that you're following their treatment plan. And you're going to do that, and you're going to be required to keep probation informed. But it's the order of the court that should be put under community control. You must obey all laws, all jurisdictions, conduct yourself in law, body, manner at all times, report when as directed. You must be honest and take you to the probation department. any firearm, ammunition, or dangerous. If you do that, you're subject to being prosecuted. Any alcoholic beverage, nor may be present in places where they're sold or being consumed, even if anyone that's in this case is a member of a gang or a criminal group or any person that a passion could in the future influence you to commit a criminal these conditions. Later the next business day after that occurs, your supervisor information ability to pay any fee. If especially complete that, to pay the court cost. Services and comply with any treatment recommendations. Will make that arrangement, and you're required to sign a consent to these. Places to control. That HR you work. Then the probation in jail on any charges other than this?
No, sir.
All right. Well, your order to be released this morning. Your probation immediately.
Yes, sir.
All right. Thank you.
Thank you.
All right. Our other cases in person. No. Case number 22CR208, State of Ohio versus Kathleen J. Cheney. This is a hearing on a motion, and the court's sua sponte motion to seal the record. Ms. Cheney had been charged originally with a bill of information of theft in office of fourth-degree felony. She successfully completed the diversion program, paid all costs and restitution, and the case was dismissed with prejudice upon notification from the prosecutor's office, and no objection has been filed, so the order motion it's ordered that her record be sealed.
That's okay. Thank you.
Case number 22 CR 189, State of Ohio versus James Williams IV. Appearing on behalf of the states, Assistant Prosecutor King. Appearing on behalf of the defendants, Attorney Danielle Witt. You're James Williams IV.
Yes, Your Honor.
All right, Mr. Williams has entered a plea of guilty to aggravated possession of methamphetamine, a fifth-degree felony. The matter was referred to the probation department for a pre-sentence report, which I have received. Of each of the attorneys had an opportunity to review a summary.
State has, Your Honor.
Yes, Your Honor.
All right, the court will note that Mr. Williams is referred to drug court. However, he lives in Beaver Creek, which is either Greene or Montgomery County. I'm not sure what part you live in. Greene. So that's not in our catchment area. So he would not be eligible for that. Okay. Mr. King, anything on behalf of the state?
Only was contained in the plea agreement, Your Honor.
Ms. Witt?
Yes, Your Honor. We asked the court for community control for Mr. Williams, and albeit that he is not eligible for drug court, that he'd be able to participate in community control. It's my understanding that he is, since being in pretrial supervision, been compliant with probation, and also has an outpatient assessment scheduled, I believe, for the 19th of this month for his substance abuse problem. So we just ask the court to take that into consideration.
Ben, would you bring me a new community control entry? And we need some copies of the new one put in this folder. These are the old ones. Mr. Williams, is there anything you'd like to say?
Yes, Your Honor, I would just like to first off apologize to the court and just let you know that I do accept responsibility for my actions and inactions, and let you know that something that's been different this time than in my past is I just spent 18 months in the county jail between Greene County and Highland County, and that's been the biggest eye-opener, worst experience I ever had in my life, and it's definitely got my attention, and I'm definitely clean and sober and plan to remain clean and sober without any doubt whatsoever, and live a successful life once and for all. Enough's enough, and it's time to be a man and have a career and have a life and have a future. And I'm almost out of time. I'm already 42 years old. I don't want to be standing in front of you at 52. And thank you for your consideration.
Now, were you in any treatment while you were in the Greene County Jail?
AA and NA meetings.
Okay. I know they have a residential program there in the jail.
Yeah.
You weren't part of that?
The green leaf, you have to be sentenced to it.
Yeah. Did you complete that?
No, I wasn't sentenced.
Oh, you
to
weren't
it.
sentenced to that? Okay.
Yeah.
When were you released from jail?
Here in Highland County on bond December 4th.
Okay, just to this month? All right. Where's your assessment scheduled?
Recovery Council buying Frisch's.
Okay. Well, if you're a resident of Greene County, I don't think, well, I don't know if they'll take you or not. That's that's part of FRS, and I think you have to be a resident of their area they cover. So it may end up sending you to Greene County. So, but since you're a resident there, who made that? Did you contact them yourself, or
Yeah, I went in and did the paperwork.
did you tell them where you live?
Yeah, and for now, I used my Aunt Barb's address, and
Who's that?
Barbara Coulter and James Coulter in Newmarket.
Okay, but are you staying down there?
And temporarily, I went to the shelter here in Hillsborough and paid that FRS transportation. That's how I got here today. And I'm working on trying to bring myself here to Highland County. And I put in an application and got an interview at Seal Tight, and hoping to tell, I did a drug test for them yesterday at Highland District Hospital for third shift, 10 p.m. to 6 a.m. and hoping that they'll hire me, and if they do, and I can get everything switched over here, then I'm just gonna stay here, so that way I have free
Okay.
transportation and don't have to worry about driving.
Well, if you become a resident of Highland County, I think you could still be admitted to the drug court docket later, and I think you should consider that because, quite honestly, with your record, Mr. Williams, you've had a long history, numerous felony convictions, and I know you say that you're confident you're going to stay clean, but I've heard that so many times and from people. Most of the time they believed it, but unfortunately the disease that you have is one that oftentimes that overrides your intentions. And so I think drug court is your best shot at staying clean. Sounds like you're doing all right now, but you've only been out of jail a week, and that's a big problem for people with, especially this time of year. So order the court that you be sentenced to a term of community control for a period of 3 years. Right now, that can't be the drug court, but if you do establish residency, then I would encourage you to apply for admission to the drug court. And if you apply, you will be admitted. But I don't order people into drug court because that has to be your voluntary decision. Because the focus of drug court is for people who want to stay clean and not just stay out of jail. That's why I think it would be a good program for you. But you'll have to make that decision, and you can apply once you do. If you do get a job here and you decide you're going to stay in the area, then you'll become eligible to be in our drug court, because you have to be in our county or an adjoining county to be in drug court, because you'll have to make a lot of appearances. You're subject to calling in every day to be tested, and usually go in 2 to 3 times a week to be tested, at least for the first 3 months. It tapers down after that if you're clean, and there's a lot more involved. And so I hope that you'll do that. But it's your order the court to be put under community control for a period of 3 years under these conditions. You obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed, be truthful in all statements you make to probation. You must keep them informed of your residence and place of employment at all times, may not change either without prior permission. May not leave the state of Ohio at any time without prior written permission. You're not permitted to enter upon the grounds of any correctional facility of any jurisdiction, nor to communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You may not purchase, possess, own, use, or have under your control any kind of a firearm, ammunition, or dangerous ordnance or weapon of any type. To do so would be a violation of both federal and state laws, subject you to being prosecuted for that, and it's also a violation of these conditions. And you're not to have any other weapon of any type while you're under community control. You're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has effects similar to controlled substances or drugs abuse, unless you have a lawful prescription. Nor may you have any instrument, device, or thing that can be used to administer drugs, prepare them for administration or use, unless you have a prescription for that device as well. And you must provide copies of any prescriptions to the probation department within 24 hours of receiving them. You must submit to drug testing when and as requested. You may not purchase, possess, use, or have under your control any kind of a alcoholic beverage, nor may you be present in places where they're sold, being consumed, even if it's otherwise lawful. You're not to associate with anyone who is a co-defendant or has a criminal record, is a member of a gang or any other criminal group, or any person who has in the past or could in the future influence you to commit a violation of these conditions. You may not, after the date of this order, marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by the probation department for evaluation or assessment for any treatment, therapy, counseling, training, or educational programming, you'll submit to that. If any programming is recommended, you'll enroll in and follow that during the pendency of this action. You'll be required to pay the court cost and make payment arrangements to do that. And you'll be required to be evaluated for substance use disorder. That's abbreviated as SUD in your entry. And complete successfully any recommended treatment. And by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you, used by you, or any other property places under your control where you're found at any time by any officer of the probation department. There'll be no fine imposed or driving suspension. You're ordered to pay the court cost as a substantive order. If you don't make payment arrangements and pay those payments, then the clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then in addition, the court could order you to do community service, give you credit for each hour you work in and out of the rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file a written notice out with the court. There will be a hearing. You'll be entitled to have an attorney. If the outcome of that is that you have failed to comply, then at that time the court could revoke your community control and sentence you to a period of between 6 and 12 months and fine you $2,500. And if you should be convicted of another felony offense while you're under community control in this case, then if you're sentenced to prison in that additional case, that sentence could also be ordered to be served consecutively to the sentence in this case. If you are sentenced to prison, upon completion of that prison term, it is possible the Adult Parole Authority will put you under post-release control for a period of up to 2 years under the terms they set, and if during that period of time they determine that you have failed to comply, they can return you to prison and make you serve an additional period of up to 1/2 of your prison term for one or more violations. But if you've committed a felony offense while under post-release control, then in addition, whatever sentence the judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively the sentence in the new case. All right, so that completes your case. You'll report down to probation here immediately to let them know you've been put on probation, and they'll go over the paperwork with you for that. And like I said, I would strongly urge you to consider applying for drug court if you do become a resident of this county or an adjoining county, because I think that would be your best bet, staying clean, because you've dug a really deep hole for yourself, and it takes a long time to dig out. It can be done. We've got lots of people that are doing it, mostly in drug court, but there are others who have done it without drug court. But it takes a great deal of determination and self-discipline and the ability to overcome adversity, and that's hard to do. I would again encourage you to consider applying for drug court if you are able to establish residency here. Anything further, counsel?
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
Please rise.